Welcome to the Wayfinder Podcast, hosted by SoFar Ocean. Today we're talking to David Richards, the director over at Shearwater Law. We talk about what the law has to say about weather-related cargo loss and damage, why the perils of the sea defense is not as strong as some may think, and why the routing decisions you make before you ever leave port matter now more than ever. Thank you for listening, and I hope you enjoyed today's episode.
Weather has always shaped shipping, but the legal and commercial consequences of weather disruption are becoming harder to ignore. From the grounding of the Ever Given due to wind to recent container losses during Atlantic storms, weather-related incidents are creating huge operational and claims exposure. Today, we're joined by David Richards to discuss weather-related cargo claims. David is a director at Shearwater Law, former deputy global head of P&I claims at NorthStandard, and the author of Cargo Claims, the Essential Guide, published by Informa Law. David, welcome.
Thank you very much, Nick. Pleased to be here.
Now, let's set the scene a little bit for our listeners. When does bad weather stop being an operational challenge and turn into a cargo claim?
I think for a cargo claim, it's when the effect of that weather is to produce either cargo loss or cargo damage. So some sort of physical effect to the cargo. You can also have a cargo claim where the weather is sufficient to cause delay to the ship, but that's much rarer. You're generally looking at weather which has somehow caused damage. So that might be, for example, because there's been a cargo shift. So the cargo's moved within the holds, the other cargo spaces, broken free of its lashings. Or it might be that water has actually got into the holds through, for example, the hatches, which are generally only weather tight, not watertight. Or you can also have weather which is warm. So some cargoes are heat sensitive, or it might shorten their shelf life. Agri-products, for example, like soybean, are heat sensitive, and you get the phenomenon of ship sweat, where water emanates from the cargo and then condenses on the hold and falls back onto the cargo, causing water damage. It's that sort of thing.
Okay. And are there any particular types of weather that more frequently lead to these kinds of claims?
So, of course, more extreme weather is more likely to lead to a cargo claim. So storms, very rough seas. Mariners talk about green seas shipped on deck. So you have weather which is so bad that it's washing over the deck. Anything which causes the ship to roll or pitch violently, so that you could lose containers overboard, or you could have cargo within the hold which is strapped down, but those lashings, that strapping breaks. So that would be rough weather, storm-like conditions. You could also have unexpectedly hot conditions. A vessel is on a voyage through warm waters, and the hot weather causes the cargo might be, I mentioned earlier, agri-products, things like soybeans. Chemical cargoes also can be affected by hotter weather than expected, particularly if that chemical cargo has a stabilizing agent in it, something like an inhibitor, which is designed to prevent it from polymerizing during the voyage. Things like that can also be weather-related problems for cargo.
Absolutely. Okay. It sounds like an awful lot. Then most cargoes, from the sounds of it, have opportunities for that. I mean, do people often underestimate their exposure, or is shipping so professionalized these days that people are generally fairly aware of the risks and take appropriate measures?
I think shipping is always aware that weather is a significant factor in any voyage, and will take a lot of steps to do pre-voyage planning. But a lot of the consideration is more about efficiency, fuel consumption, prosecuting the voyage as fast as possible. It should also be considered whether the weather is likely to affect the cargo, and a prudent operator would think about that and plan for it. But in fact, the legal side of it has been quite generous to carriers when it comes to routing decisions and voyage planning, which doesn't maybe take into account weather as it should. So there was a case in 2020 from the High Court in England called the Santa Isabella, which is quite interesting in this area. It was a ship that had loaded a cargo of maize in Mexico and was taking it to South Africa and went via the Cape. And the allegation against the carrier in that case, or one of the allegations, was that that wasn't the proper voyage to take because the cargo interest said it should have gone through the Panama Canal. And when the cargo arrived, it was damaged with caking on the surface and wetting to the cargo. The judge was fairly sympathetic to the carriers in that case and said that routing decisions would not normally represent a failure to care for cargo, except for in quite extreme and rare situations. So, for example, the judge said specifically holding a course through the middle of a storm where it could be reasonably expected to result in cargo damage, that would be a bad routing decision which failed to take account of weather in breach of the cargo care obligations.
Yeah, it's very generous to carriers from the sounds of it. I mean, do cargo claims occur more frequently in certain regions than others, or on certain trades or certain cargoes?
I think it's the nature of the cargo really that matters. So if it is in some way secured, then that is always going to be at risk of weather affecting the ship. Whereas your bulk cargoes, grains and things like that, are more likely to be affected by water ingress or by prolonged voyage times, ship sweat. In terms of regions, again, it depends on the cargo. Most insurers will hold their breath before the Atlantic winter season sets in because they know they're going to see an uptick in claims. You can track it year on year, seeing more claims come in, which are weather related as you approach that winter season. Or if ships are going around the Cape in South Africa's winter, you're going to see more cargo claims in that region as well. Even more incidents like groundings.
Now, there's been some predictions from meteorologists that there might be a super El Niño later this summer, and obviously that can bring some fairly extreme weather. Is El Niño one of those things where insurers or lawyers like yourself will be expecting an uptick in claims?
It's certainly extreme weather events would likely produce claims. We've seen certainly in the last few years, for example, an increase in container losses. So it's be a regular occurrence now that containers will be lost overboard. You may even have a full stack collapse. We've seen some very severe incidents. And recently there's been an amendment to SOLAS to require carriers to report container losses, and that represents, I think, the increasing frequency of those occurrences. So I think, yes, those super weather events will cause some worry and need to be planned for. And I think there will be an expectation by the courts, at least, that if there is cargo damage, that a cargo carrier can show that they planned adequately for that event.
Okay. And when disputes do arise, what tend to be the facts and evidence that make a biggest difference with an arbitrator or a judge to decide the outcome?
First, as I said just now, pre-voyage planning is increasingly important. Ever since the decision of the Supreme Court in the Libra, we've seen an increased emphasis on pre-voyage planning, because you can't hold a carrier liable generally for unseaworthiness that occurs once the voyage has started. But things that are done before the voyage begin, they can be examined to see if the ship was seaworthy because the way the voyage was planned for. So you need to have good evidence that you have planned the route properly, you've anticipated the weather, that your stowage and cargo securing is adequate for the anticipated voyage, and you're not taking a generalist approach to this so that you're thinking, well, this is always how I've secured this cargo. But if you are expecting a very extreme weather event, I think the court or arbitrators would expect to see particular attention paid to how are you going to carry out this particular voyage. Otherwise, it's going to be good records from the ship. So if you have an issue which results from ship sweat, cargo condensation, then good ventilation logs, following, for example, the 3-degree rule correctly, will be very important. Evidence that the hatches were tested for integrity so that they are weather tight, things like that. Contemporaneous documents generally always being preferred by a court or an arbitrator compared to factual evidence given after the event, when the damage has already occurred. In terms of weather reporting, weather reports are quite important to preserve, but you can get very accurate hindcasts these days. So there is a weather-related event. You can ask a meteorologist to do a very accurate hindcast that tells you exactly what the weather was like on the day in question. And of course, what you're hoping is that corresponds well to the logbooks.
Okay, excellent. Now, you mentioned contemporaneous evidence being valued more highly than something that's recorded later on. Are there any other sort of common early mistakes that seafarers or shore teams should be avoiding, particularly in that sort of critical first 24 hours after an incident?
I think it is important that steps are taken to preserve evidence. VDR, for example, that should be saved if there's been a significant cargo damage, that the logs are accurate. The main mistake is often, I'm sad to say, trying maybe too hard to make sure that everything is as it should be, and maybe logs being looked at afterwards that were not as accurate as they should have been, maybe filled in after the event, crew that give an account of what happened that doesn't marry up with the huge amount of electronic data you can get these days. So really it's about collecting that evidence, not trying to do anything with that evidence which is improper. And the one thing I think that might surprise people that doesn't help are sea protests. I think a lot of mariners believe strongly in the magic of a sea protest, this ancient thing that will somehow protect you, and rush off to issue them. They can have importance in some countries, but generally from an English lawyer's point of view, a sea protest is more likely to do harm than good in my experience. It's better, I think, to record a statement through a surveyor, the club, or an external lawyer that is properly taken than to dash off a sea protest that might not be as helpful as you intended.
Got it. Okay, excellent. Now, improved forecasts and weather data, as you mentioned earlier, particularly when it comes to hindcasts, are they changing how these claims are argued or settled? I know you mentioned earlier, there's quite a lot of leeway given to carriers, in particular for voyages that are already underway.
I think that sort of data, the actual weather data, the hindcast will tell you exactly what the ship experienced. So you can be very confident that on this day at this time, it was experienced Beaufort scale 10. These were the conditions. You will often find that the crew's recollection is not entirely accurate. Crew will often describe the ship as listing 45 degrees when that's not possible. But people's experience of weather, understandably, your recollection can be more colourful than the actual events. I think what's probably more important these days is looking at how the routing and the pre-voyage planning was carried out. Ships these days often follow routing advice. The master is not planning his route himself. He's not making course corrections based on his or her own judgment. the master is often receiving very detailed day-to-day advice from a routing company, but there will be increased focus, I suspect, on how those are set up. So what instructions were given to the routing company? Were they told to prioritize speed over safety, cargo safety, for example? And the reality is there's so many tools now available to a master for route planning and for conducting the voyage, that evidence is going to be pretty important in a major cargo claim.
It sounds like the improved data that we have these days is perhaps better used or more frequently used to defend claims rather than necessarily to prevent them. Would you say that's accurate?
From my point of view, that's how it must seem, because I'm a lawyer that either prosecutes or defends cargo claims. But I'm sure from a ship operator's point of view, they are using that data to carry out safe planning of future voyages. So for them, they are looking at that weather data, those weather forecasts, to try to plan the most efficient and ideally the safest route from A to B.
Okay, got it. Are climate change's effects visible in the weather-related claims landscape? When you look back to the start of your career a few years ago versus now, is there much of a difference?
I think that's hard to determine. It certainly seems that we are seeing certain sorts of incidents more frequently, like container collapses, but there could be a myriad of reasons why that is happening. And when I look into why a container has been lost overboard or why there's been a stack collapse, weather is not the only cause. It's certainly an cause, and it's often the cause which operated last in time to make it happen. But I think it's too early to say whether there has been a demonstrable increase in claims or particular types of claims because of climate change.
Okay, excellent. And if you had the opportunity to speak to shipping companies, about how they could reduce their exposure to weather-related cargo claims, is there one big tip you would give them?
I think good planning of voyages, anticipation of the voyage that is going to be undertaken is essential, as well as good record keeping, stowage that is accurate and well documented. The importance of ventilating cargoes can't be understated. It's often the case that ventilation won't prevent inevitable cargo damage, which results from the inherent characteristics of the cargo, i.e. it's too hot and it's too wet. But the absence of logs that show that ventilation was at least considered and where appropriate carried out can be very damaging. I think the other thing that might come as a surprise to carriers is that the traditional defences in this area are perhaps not as strong as they might first appear. So most ship owners and operators will be aware that there's always been a defence of act of God to cargo claims, even from the days when a carrier's obligations were pretty strict. And that defence now exists largely in the Hague and Hague-Visby rules as the peril of the seas defence. And I think a lot of people hear that there's a peril of the seas defence and think, well, if damage is caused by heavy weather, I'm protected. But the reality is that the courts have said on the peril of the seas defence that the weather has to be both unforeseen and exceptional to allow you to rely on that defence. So in one case, even weather up to Beaufort scale 10 was not considered to be sufficiently extreme to allow a carrier to rely on the defence. And even if you could rely on that defence, you might still be found liable for cargo damage if you've not properly planned for the voyage and the weather that you could be expected to face.
Impressive. Both at 10, it still didn't count. Goodness.
At that time of year in that place. I think if you found that in the middle of the channel, the English Channel, that might be different. But at certain times, that is expected. And you mentioned climate change earlier. The reality is, if weather is getting more extreme more regularly, that will therefore not be a peril of the seas. That will be a routine voyage planning issue.
Okay, excellent. David, thank you. This has been a fascinating discussion about where weather, operations, and legal risks intersect, and what the industry should be paying close attention to as weather-related disruption continues to evolve, particularly with several meteorologists predicting we'll have a super El Niño this summer. David, thank you very much for sharing your insight and experience with us.
Thank you very much, Nick. It's been a pleasure.
And to our listeners, thank you for joining us. Please follow or subscribe at the links in the comments for future editions of Wayfinder. And you can also find a link to David's new book in the comments as well.